Tanya, you were still having some people join us, so you can start whenever you want to, but I think we're up to 30 or so participants, so we'll probably have a few people joining us hopefully soon.
I wanted to ask
Okay,
about,
I think I see our Chief Counsel, Brad Gessner. Brad, are you on here? Yep, I see you. Okay, great. All right, we're going to begin with Brad Gessner, who is our Chief Counsel. He is the head honcho. He's been through a lot, has had a lot of experience being a prosecutor, and we're really lucky to have him here today. And he's going to talk to us about, the ethical obligations of the prosecutor. And I think James is going to share screen for Brad. Brad, welcome. Thanks for being here.
Thank you. Good evening. I think someone
I can't
had a
hear
question.
you. I don't know if anybody else can.
I can hear Brad. I can hear
Okay.
Brad.
My mute was off. Okay.
I can hear.
All right. Everyone okay? If not, raise your hand. All right. James has a screen up there with a PowerPoint. We're going to talk about prosecutor ethics, and just wanted to let everyone know, first of all, we're really excited about having all of you here and hoping that you learn more about what our office does, and some of those preconceived ideas of what prosecutors are you might find out aren't exactly fact. But prosecutors in the law in the state of Ohio, we are the only attorneys in the entire legal system that have an obligation to do what is right. Okay, we're not representing a client, we're representing the system of justice. And for justice to occur, truth and right has to prevail. So that's our job. We're not defending someone and doing the best we can for our client. We're doing the best we can for the justice system in our country. So we take these things very seriously. The American Bar Association has rules of conduct for lawyers, all the lawyers. Go back, James, don't move yet. Okay, for all lawyers. And the ABA, out of all the lawyers in the world, decided the only ones they had to write specific rules about were prosecutors. And they did this because relationships between prosecutors and defense attorneys have been rocky in the past because we go to battle and we fight. But they've said, despite the common ground of law school, what we've learned together in that, we have distrust that has grown through the years and has hardened. So the ABA said, we've got to make a specific rule to apply to this. So go ahead, James. Okay, so there's a call for greater civility and collaboration for us, again, to help the system become fair. But the ABA has rules that specifically only apply to prosecutors, talking about our ethics, because what we do is so important. The decisions we make affect people's lives, and we always have to keep that in mind. Okay, James, go forward. Okay, the case I like best to talk about ethics is a United States Supreme Court case from 1967, and it's still a valid law and still on the books, United States versus Billy Joe Wade. And in that, Justice Byron White said prosecutors have the obligation to convict the guilty and to make sure they do not convict the innocent. So now defense attorneys don't have to make sure that the guilty get convicted. They're even supposed to fight that from happening. But prosecutors, we have that dual obligation. Next page. And defense counsel has no comparable obligation to ascertain or present the truth. James, next. So it boils down to the job of the prosecutor is the truth. Okay, now we're going to go on to those ABA and NDAA rules. Now the NDAA is the National District Attorneys Association, to which Prosecutor Sherry Bevan Walsh is a member of their board of directors, and she is very active in that. So the ABA rule I told you about, prosecutors have to refrain from prosecuting a charge that isn't supported by probable cause. So if there isn't good reason to believe someone did something, we are not to charge. The National Prosecution Standards has a whole list of things that we're supposed to consider and not consider, and it said charges should only be filed that encompass the offense we believe was committed. So we're not supposed to go beyond that. Just what we think we can prove and prove by admissible evidence. Next page. Okay. And then the Ohio Rules of Professional Conduct. So we've got the ABA, we've got the National District Attorneys Association, and then we have a rule in the Ohio Rules of Professional Conduct. A prosecutor has a responsibility of a minister of justice, not simply that of an advocate. So we don't stand and fight for someone. Again, we fight for that principle of justice. Okay. So the best example that I can show you and try to show you quickly, and it's a long story, and we're going to try to make it short tonight because we've got two other speakers. This is the responsibility of an American prosecutor, and the case is based on the failure of a prosecutor to do what they were supposed to. And this is the case called Brady versus Maryland. This is a United States Supreme Court case from 1963, and it was a landmark case that said prosecutors have to turn over all the evidence that could exonerate a defendant. Anything that shows a defendant might not have committed the crime that we're accusing him of, we have to give it over. There's no such thing as trial by ambush if you're a prosecutor. You have to give everything to the defense. They don't have to give their information to us, but we give everything to do this. And in the Brady case, the prosecutor failed to turn everything over, and Brady was convicted, and we're going to talk about that story. So it was a landmark case. It was never meant to be a landmark. It actually took a life of its own. So the court ruled, they ultimately held Brady would stay in prison for the crime he was convicted of, but the law outlived Brady. And the parts of it which talked about the responsibility of the prosecutor became greater and greater over time. And it's what every prosecutor can tell you what Brady versus Maryland means. It means we don't hide evidence. We turn it over, the good, the bad, the ugly. Okay, so let's talk about Brady. Okay, Brady grew up poor in Southern Maryland. His parents gave him up to be raised by his grandparents and his aunt. As a kid, he suffered from some medical problems where his ears actually, like, they oozed this vile-smelling pus. He was nicknamed Stink Ears at school, so he was bullied throughout school. He dropped out of school in the 8th grade and worked full-time at his uncle's farm. In 1951, when he turned 19, he enlisted in the Air Force and became a military policeman. When he did that, and his medical problems seemed to go away, he got married, he left the service, he got his GED, everything looked good, and then his wife decided she didn't want to be married anymore. So they got divorced and he returned to Maryland. At the age of 25, he met a 19-year-old girl named Nancy Boblet, and he was friends with her 25-year-old brother, Donald. Donald was barely literate, and Nancy, at the time they said, she was a dumb, good-looking blonde. And this comes from the history books, not from me. Nancy was married at the time to a guy named Slim, and she and Slim lived with Nancy's parents. Well, believe it or not, Brady and Nancy fell in love, and she ended up getting pregnant while she was still married to Slim. So Brady knew he needed to get her a divorce so they could be together, but he made $1.50 an hour at a tobacco packing plant. He was behind on bills. He had a 10-year-old car, but he wanted her to know he was serious. So he took one of his checks. You know how the bank gives us checks? That doesn't mean we have money. Well, he took a check and wrote her a check for $35,000, amount that he thought could solve all of their problems in the world, even though he didn't have a nickel to his name. So since he didn't have the money yet, he decided he would post-date that check for $35,000 for 2 weeks away. And he told her not to cash it until July 6th. Okay, James? So in order to get the money to put in the bank, Brady talked to Donald, his future brother-in-law, he thought, and they decided they would rob a bank. So they decided the best day to rob a bank back in the 1950s was on a Saturday, since everyone would have deposited their pays on Friday and the bank would have a lot of cash. But Brady also decided his old Ford wasn't going to be reliable enough, and if they ended up in a chase, that he wouldn't be able to outrun the police. So he knew an old friend who had just bought a beautiful new car. His name was William Brooks. He was 53 years old, and he was an old friend who worked on the farm and stayed with Brady's aunt. Next slide. So Donald, next slide after that. Okay, so Donald and Brady decided they would stop Brooks on his way home from work at midnight and steal his car. They dropped a tree on the road to make him stop. Brady and Donald, who didn't want to be recognized, they would blindfold Brooks, they said, tie him up and stow him in a vacant house. And then after the robbery, they'd give him his car back and let him go. So they thought they had a great plan. So Brady told Donald he didn't want Brooks hurt, told him how good Brooks had always been to him. So they put that log across the street, the narrow road. Brooks pulls up. It's dark out. He stops, gets out to move the log. Donald steps out in the darkness and has a double-barreled shotgun. Brooks yelled, "Please don't kill me." But Donald hit him in the back of the head with the shotgun and knocked him out. So at that point, they loaded him in the back seat of the car. And Brady drove off saying they needed to leave him in the woods somewhere. And Donald said, "No, we have to kill him because he saw me." Brady told Donald to put the gun away before someone got hurt. When Brady stopped and looked at the woods for a good spot, Donald took his shirt off, twisted his sleeves up in the shirt, and strangled and killed Brooks. Next slide. Brady had run back to the car, realized what had happened, but it was too late. Brooks was dead. They carried Brooks' body back into the woods, covered him with branches, and left him there. And they drove off, and by dawn, Brady had said they had done enough, that he would end up not robbing the bank. They had to take the $255 from Brooks' wallet, and they decided to buy bus tickets and flee to Washington State. But by the time they made it to Virginia, Donald was homesick already, just after a couple hours, and wanted to go home. So they left the car in Virginia and bought bus tickets back to Maryland. At that point, next slide, Brooks' landlady reported that he was missing. She called the police. She also told the police she had seen him around Brady. And Brady heard about this and panicked and went to his aunt's house in Washington, D.C., and she said, "The police are here looking for you." So he had met some Cubans while he was in the Air Force, so he decided he would flee to Havana, Cuba, and become one of Castro's rebel fighters. Now, this is all history. I'm not making this stuff up. Okay, shortly after he arrived, Nancy, it's about July 6th, goes to the bank to cash the $35,000 check. It was a few days early, but the ladies at the bank laughed at her and they told her this guy doesn't have a nickel to his name. And Nancy felt humiliated. Now, Brady felt bad about this because he knew he was only guilty of stealing Brooks' car, and he loved Nancy and wanted to make it right for her and his child she was going to have. So he went to the American Embassy in Havana and turned himself in and said, "I did something bad. I need to get back to Maryland and make everything right with Nancy." Next slide. So the embassy transported him to Miami, where he met with the FBI, and he didn't tell them the complete truth because he really didn't want to get Donald in trouble either. So he said he knocked Brooks out and he and Donald stole the car and they'd left it in Virginia. He never mentioned anything about the killing. The car was found right where Brady told him he left it. The next day, his bail was set for $25,000 for transporting a car across state lines, and he told the FBI he would plead guilty to that because he knew he did it, and he figured he'd get probation. However, by the time the police picked up Donald, Donald took him to the body, and he gave a statement to the police and said, "Brady did it all. It wasn't me. I stood there. There was nothing I could do, and it was all Brady's idea." Next slide. Now, had Brady told the FBI the truth, it might have worked out differently. So once now Donald implicated him, Brady decided he needed to tell the truth, that he had only lied to protect Donald. And the newspaper reported, these were the words in the paper: "An odd, almost senseless series of events had led to the murder charge. That astute police work was not needed to solve the case because the two men seemed pathetically anxious to get caught." So, next slide. After the arrest, Nancy and her family blamed everything on Brady. Nancy came to his cell and asked him if he killed the man. When he said no, She realized then he was going to blame her brother. She walked off, and he never saw her or their child again. So now on to the trial. Next slide. So what did the prosecutors do? Now, Donald, when he spoke to the police, gave 5 statements. And in the first 4 statements, he said Brady did everything. Ultimately, he gave a 5th statement that was the truth, that he, not Brady, hit Brooks, and he, not Brady, strangled and killed Brooks. So both men were charged with the same first-degree felony murder, because if you're an accomplice to someone, when they commit an act, you're as guilty as they are. So since each they committed the felony murder in the commission of a robbery, since each blamed the other, they were tried separately. Okay, next slide, James. Okay, leave it just like that for a minute. So when Brady was tried, the state asked for the death penalty. James, click once. Okay, and the prosecutors turned over the first statement of Donald to Brady's attorneys. Next. Then they turned over the second one. So far, both of them say Brady did it. The third one said Brady did it. Now the fourth one said Brady did it. Now the fifth one. They didn't turn this over. The prosecutors had one that said Brady really wasn't involved. He was standing there and I did it all on my own, but the prosecutor withheld that. Next slide. Okay, so in preparation for trial, defense decided to try a case for extended mercy since Brady had confessed. What else do you do? They said he should be spared the death sentence because he didn't kill Brooks. His lawyers asked for all of those statements. Again, the prosecutors turned over the first 4. After 2 days of trial, the jury deliberated for 3 hours, and 3 days later, they sentenced him to die. Okay, sorry about the bandwidth. Donald was tried by the court, and he was given the same sentence. So now, while Brady was on death row in Baltimore, he met a Catholic chaplain who found him a new attorney, Clinton Bamberger. And Bamberger read the transcripts of the trial, the bench trial, Donald's trial, and after he had already read the 4 statements that were turned over to the police, he didn't understand why in Donald's trial he admitted he lied in his first statement or in his last statement, because he said, I've got 4 statements and they're all the same. Why would one say he lied on the last one? And that way is how they realized there was a 5th statement that was withheld. Well, he appealed this, went to the Court of Appeals in Maryland, and the Maryland Court of Appeals ruled that the state had a duty to turn over Donald's confession, that he did the strangling, and the failure to turn that over violated Brady's constitutional right to a fair trial. But they said since Brady was a participant in the robbery, it was still felony murder, and Donald's confession, while a jury might have looked at it to not give him the death penalty, still would have convicted him. So they granted him a new trial, but only on the issue of what the punishment would be. So now Bamberger, he's the one that was on the right in that picture, thought the jury still might give death, so he appealed it to the United States Supreme Court, hoping that the case would get reversed. Now, when it gets to the United States Supreme Court, William O. Douglas was one of the longest-serving justices in our history, and Douglas wrote the opinion for the court, and it was a 7-2 decision. So 7 justices agreed with him, and 2 disagreed. Now, Douglas also, back at the time, had been looking to possibly be Franklin Roosevelt's vice president, was passed up for that, and Harry Truman became vice president. Next thing you knew, he was president. So Douglas always wanted to make sure he had an important spot in history. So there's some legal historians that say Douglas took this case, and the decision he wrote was to cement his part in history. What Douglas wrote was, if a state has contrived a conviction through a pretense of a trial which in truth is but used as a means of depriving a defendant of liberty through a deliberate deception, the contrivance by the state to procure the conviction and imprisonment of a defendant is obtaining a result by intimidation. So go ahead, 2 more slides, James. So What did the Supreme Court say? Next slide. We now hold that the suppression of by the prosecutor of evidence favorable to accused upon request violates due process where the evidence is material to either guilt or to punishment, irrespective of the good faith or bad faith of the prosecutor. Now, the part of that I have in italics is, so now the law, since the 1950s or since 1961 when this case came out, has gone to the point of, if the police have some evidence that shows someone didn't commit a crime and they fail to turn it over to us, the prosecutors, irrespective of the good faith or bad faith of the prosecutor, that still can get that case reversed. So we are presumed to know everything that the police know, whether they give it to us or not. So that's why it's important for us to teach the police about how important it is to turn everything over and to be fair. Next slide. Okay, the question then remains whether Brady was denied a constitutional right when the Court of Appeals restricted his new trial to punishment. In the present case, a unanimous Court of Appeals said nothing in the suppressed confession could have reduced appellant Brady's offense below murder of the first degree. Remember, he was complicit with Donald. So, but we cannot raise that trial strategy to the dignity of a constitutional right and say that the deprival of that supporting chance denies him due process or violates the Equal Protection Clause of the Constitution. So, but what I'll tell you is, since that case came out in those years since 1961, this has basically become a constitutional right. So it's not set out in the Constitution, but the case law is so supported that we will have a case reversed and retried, new evidence, if we withhold something like this. Now, next slide, James. So again, that's it. Next case, or next slide. Okay, that means they affirmed his conviction. They said it was unfair, it wasn't right, but we're not going to do anything about it. Next slide. Remember, I told you it was a 7-2 decision, meaning 2 justices disagreed. What they wrote is, moreover, uncertainty on this score is compounded by the state's acknowledgement at the oral argument here that the withheld statement would have been admissible at the trial on the issue of guilt. So some jurors may have felt that could have swayed their opinion whether to convict him on all those charges, and he had a right. However, the minority, only 2 of the 9 justices, held that way. So that wasn't then the law in the case. Next one. So the ultimate result on prosecutors. Now this is a complete other case. This one says, pursuant to Brady versus Maryland and its progeny, the government has a continuing obligation to produce all evidence required by the law and the federal rules of criminal procedure. So again, this is what we see coming down the road since Brady, is now all of the laws in the country, all of the judges in the country, all of the courts in the country are holding that obligation to prosecutors to be truthful and to be fair and turn over everything. So now let's just go quickly. In the end, what happened to Brady? No one wanted to retry him after all those years. He was guilty of the murder, but we knew something was wrong, and Maryland said, we don't want to go through a trial for punishment only. So everyone just waited. And in 1973, so 10 years after the Supreme Court had decided this, 15 years after the crime was committed, Brady's attorneys filed a motion saying they have not had a right to a speedy punishment hearing. And so both sides did their legal maneuvering. The governor ultimately in Maryland granted Brady clemency and paroled him in 1974. So without the error, he would have likely had a life sentence without ever getting parole. But 16 years after this trial, he was out of prison, a free man. He ultimately left prison, became gainfully employed, married again, had a son and daughter, was crime-free the rest of his life. He moved to Florida and he died at the age of 76 in 2009 without even as much as a traffic ticket. Next slide. Next slide. Okay, so what happened to Donald, his co-defendant? In 1972, the death penalty was declared unconstitutional, so he was taken off death row. He was ultimately paroled in 1992, but shortly after that, he was charged and convicted on a rape. He was sent back to prison for life and died there in 2002. So now in those 16 years that Brady was in prison, he wrote some journals and that to himself. And he wrote, "For 6 long, lonely years, I've watched the greatest stars march, and I wondered if I would be alive to watch them another day. I've died 1,000 deaths during these past years. Each day I die a little more. I look out upon the world and see only darkness. I am alone, without love, without friends, without hope. My only companion is fear." Click it once, James. And that is all because that fifth statement was not turned over. As prosecutors, we have to do what's right. We don't have a right to withhold something and have someone serve time in prison when they did not have a fair trial. So Brady determination is not this. It's not, do I do this or I do that? No, you turn it over. Again, we try our cases with the good, with the bad, and with the ugly because our job affects people's lives. Now, Brady, let's go on. Brady case has been cited over 110,000 times in Westlaw in cases. There are 39,315 Brady cases where cases were reversed because all of the information was not given. There are 5,000 secondary sources where they have written articles about the importance of Brady. There are 981 cases in Ohio that cite Brady. So this decision in 1963 by Justice Douglas is something that lives on. So next slide, James. Okay, this is, again, just an example of an Ohio case. State versus Newton. Trial court correctly dismissed a rape case with prejudice where during the trial, the victim testified the detective lost or destroyed a diagram the victim had drawn. The detective lied to the court in an attempt to conceal her role in the diagram's destruction. So Newton was the victim's 8th grade softball coach. The victim had drawn a diagram of part of the school building where the incidents occurred, and the diagram was exculpatory, which the way it was drawn would have helped show the innocence of that. So the court actually dismissed the case. Go ahead, the next one, James. State versus Jackson. This is one here in Summit County. While this case doesn't cite directly to Brady, it found that Jackson's due process rights weren't violated, so no Brady violation by a failure to preserve evidence where the arresting officer's dash cam system didn't record Jackson's stop because the cruiser ran out of gas and broke down. So what they say is we don't have to make up evidence, but once we have it, we can't destroy it. We have to turn it over. James, you can go back to take this off and let me be on the screen for a minute. So again, there can be nothing more important than anyone having a fair trial. Again, we turn everything over. We have Criminal Rule 16, Criminal Rule Procedure, where it says we have to give what's called discovery. So every witness statement, every tape recording, every photograph, every expert report, all has to be to the defense well before the day of trial, or the case is going to get reversed based on the decision in Brady versus Maryland back in 1963. So again, there's nothing more important as a prosecutor to see that people who break the law, people who victimize people are held accountable. But the only thing comparable to that importance is that the individuals who didn't commit those acts aren't wrongfully prosecuted. So I think I have about a minute because Tanya made me start late. That if you have a question.
You have more than that, Brad. Brad, you
If you
were
have
awesome. I try to be a stickler on time, but he really just sticks to it. I don't have to be.
Okay. So let's do, if you have a couple questions, let's answer them, but we don't want to delay you too much because Brian Stano's got a great presentation coming up next. So are there any questions?
I don't see any in the chat. I'll let somebody unmute, but I will note NPR just released that. I don't know if anybody watched the podcast Serial, the first season, but Adnan Syed just got released based on a Brady violation. So
Okay,
Brad
there is a question,
just
Tanya.
shared
Okay, Tanya, I do have a question.
that.
Okay, how is it possible for county prosecutors in different counties to pick and choose what they will prosecute? For example, when we had some county prosecutors who would ignore some state orders on COVID prevention measures like masking. Okay, first of all, the 88 counties in Ohio, every 4 years, the same time as the presidential election, elect their county prosecutors. County prosecutors are sworn to uphold the law, but it also says that when we charge someone, we are to consider the likelihood of a conviction before we charge someone. So if we have some facts that we go, you know what, the people in Summit County do not feel this way, and they are completely and totally opposed to this and may not and are unlikely to support this, there is some discretion left for prosecutors in determining when to charge. So that's probably the best answer I can give to that. And if Brian Stano has a better one, he'll give it. Otherwise, he'll go on to his subject. So
We
thank
have
you so
another
much.
question. We have one
Okay.
more question. If the
Okay.
defense has information that proves that the person is guilty, do they ever have the obligation to give that information to the prosecutors?
Rarely. Okay. Now, if they know their client is going to go out and commit an offense is on their way, they're going to have an obligation for the safety there. But they can't take something and destroy it, but they do not have to tell us about it. The defense, we were taught in law school, cannot lie, which is why a lot of defense attorneys will tell you, when my client comes in, I tell them I don't want to hear their side of the story. I'll look at all the facts, all the evidence, and I'll talk to them. Joe Gorman's a good defense attorney in town. He always says, I always tell my clients when they come in, once I read this, we've got 3 doors, and there's some that you don't want me to open. Okay, some of them are telling the truth, some are going to trial, and some are keeping quiet. So that's a lot of times where you see a defendant may not testify, or we were also taught in law school, if you're a defense attorney and you know your client is going to get on the stand and lie, you are not permitted to promote that lie, but that individual has a right, that defendant, to testify. So you say, can you tell the ladies and gentlemen of the jury your name? And what else would you like to tell them? So you're not part of the lie, but you're letting them have their right to testify. So it's not always perfect, but if it were perfect, it would be because of the prosecutors. And I'm joking too. We work hard to do what's right, and we, in our office, I have trainings and teach people what's right, and we take our jobs very seriously. And I'm proud of the job we do in the office, and I'm so glad all of you joined on this to see what we do and ask the questions and make us prove our cases to you also.
So I'm sorry. So the goal is not to actually prove the truth, but to prove the evidence.
Okay, the evidence proves the truth.
But if it's if someone is like not saying anything and they're guilty, and that's omission. So you're basically drawing a conclusion based off of evidence or the supposed evidence and not necessarily fact. I'm
going to agree with you if you're the defense. Now,
Okay.
if you're the prosecutor, we're the ones with the burden of proof. The defense has no burden whatsoever.
Okay, gotcha.
Okay.
That changes things, the burden of
Yes.
proof. Okay, thank you.
All right.
Okay,
Okay.
it doesn't look like we have any more questions in the chat. Brad, thank you so much for being here and for your time.
Thank you all. Enjoy your class.
Have a good night.
Thank you.
Thank you.
Okay, so next we have Brian Stano, who is a supervisor in our criminal division, and he is going to be talking to us about what Shante just asked about, burden of proof and forensic evidence. So Brian, I'm going to let you take it away. I see you here, so I'm going to.
Okay. Can you hear me?
Yes, we could hear you.
Yes.
For some reason, my laptop wasn't working, so I had to go to my phone, plan B. But hey, as long as it works, then that's all that matters. Okay, so yes, thank you very much, Tanya. My name is Brian Stano. I've been with the office for 15 years as an assistant prosecutor, and I'm going to be talking to you for a little bit about forensic evidence and burden of proof. Just before I begin, I think what you all are doing is awesome. I love it when people take an interest in the justice system and try to learn, about, what's going on in their communities, especially the prosecutor's office. A lot of times, for some reason, I used to think my job was really interesting to people. But then, I would notice when people found out what I did and I told them, they didn't want to ask me any questions. Maybe because some people didn't want to know, some of the darker things that might be happening in their community. But I think it's incredibly interesting, and I think it's great that you all are here and learning about what it is we do. My presentation, what I really focus on, and I'm going to talk about forensic evidence and burden of proof, and I'm going to get into things like DNA and fingerprints and firearms and scientific evidence. And I only have, so long. I mean, all of you could go on Google and probably read about DNA for a day. What I like to focus on is what we see on the ground, in the courtroom, what we're doing on a daily basis, kind of the more practical realities of some of these things. And so that's kind of where I focus, my presentation. So what do we mean by forensic evidence? That's basically any evidence that I would call, or anybody would call, scientific. That usually does include things like DNA and fingerprints and blood evidence and that kind of thing. And we do use that stuff. Now, if any of you, if you watch TV or true crime, there's a lot of cases that are, impacted by forensic evidence. Our most common form of evidence is probably good old-fashioned testimony. Somebody was at a location, they saw something, and they come into court, and here's what I saw, or here's what somebody said. But when it comes into forensic evidence, there's a lot of times there's cases that we're relying on science to try to prove a certain element of our case, or recreate something that happened at the scene. So we can go to the next slide. Okay, here are some of the examples that we have of forensic evidence that we use in court. DNA is a big one. I'll talk about that a little more. Obviously, firearms, guns. We have lots of violent crime that we prosecute, and we'll get into shell casings and things like that that could be found at scenes that we use. Even sometimes a little more rare, but trace evidence. They find fibers at a scene, or just one drop of blood. I once tried a case where there was a tiny drop of blood on the inside of a doorknob. I tried a burglary case that way. Every once in a while, we'll get into handwriting. If somebody commits fraud or forges a check or something like that, we might get into some handwriting analysis. I know I've used that. And fingerprints, I know that's the one everybody knows. It's a little less common these days with the advent of DNA. And we'll talk a little bit about how fingerprints, they're not always as easy to detect as DNA and some other things. And then we'll get into some of the other things too, like accident reconstruction, chemical analysis, pathology, and even entomology. We'll go to the next slide. Okay, DNA. Obviously, sources of DNA that we could be left at a crime scene. Blood, body fluids, skin cells, organic material. That the reason why DNA is helpful in criminal investigations is obvious. The DNA is unique to an individual, except for identical twins. But DNA is unique to a person, and that's why it can be used, in criminal investigations. One of the things that we see, and this is more my practical kind of approach, is sometimes DNA, it doesn't always solve the crime like people think it is. Well, you have DNA evidence. It's an open and shut case. Well, that's true to some degree, but more and more we see not just DNA evidence, but how did it get there? That's more what we have to, the DNA analyst can come in and they can say that drop of blood belongs to this person, but sometimes we have to look at the context of the facts of a case to try to understand how that DNA evidence fits into the case. One of the examples I used before is a drop of blood on the inside of a doorknob. We said, well, okay, the homeowner doesn't know who that person is. If their blood's on the inside of the doorknob, then that must mean they're the burglar, right? Well, in that case, the defense came up with several reasons why, that didn't mean he was the burglar. I won't get into all the facts of that case, but there's an argument over how it's deposited on a surface. Obviously, one of the biggest DNA challenges we have are sexual assault cases. And you'll have an entire session on sexual assault cases, I think later, maybe next month. But really, DNA doesn't always solve sexual assault cases like we think it would. The exceptions are maybe if it's a stranger sexual assault, stranger rape, or if it's a child, then DNA definitely makes an impact. But as someone, I've prosecuted a lot of rape cases. Most rape cases aren't those cases. They're the kind of ones where it's consent is an issue. And what I'm getting at is if DNA is in a rape kit or found in the body of a victim, if the defendant or the suspect claims, well, it was consensual, yes, we did, have, sexual relations, but it was consensual, then the DNA doesn't help us, obviously, in that kind of case. So we need to talk about how it got there or why it's there, unless somebody denies it. So DNA can be helpful, but it's usually only still part of a criminal case. It's not always like the thing. We still have to prove other elements of the case and get people to come in and testify and use other kinds of evidence other than just DNA. So those are some of the kind of current issues that we're facing when it comes to DNA use. Okay, next slide. All right, guns. This is obviously a very big part of forensics, is firearms. And actually what you see here, I found on the internet was pretty cool. For those of you who don't know maybe how guns work, I mean, I bet there are a few people who are like, I know exactly what that is. But some of you may be wondering, wow, what's going on there? I use this illustration because most guns, and this is, a semi-automatic pistol, the things that are in the grip there all together, that's the bullet and the casing, that all together is called a round. And what you see fired out of the gun that's going through the barrel is actually the bullet. And what's kicked out of the gun is the shell casing. So that's really, for most guns that are semi-automatic pistols, this is how a gun works. And what forensics can do with limitations, if the bullet is fired, just that piece at the tip, because what's fired is only that little piece at the tip of the round, of the cartridge. If that's recovered, not to get too graphic, but if it's recovered from a shooting victim, the body of a shooting victim, or sometimes it could be recovered from the wall or a tree, they can compare that bullet to the gun that fired it. Say they fired, there's a homicide and that, they don't find the gun. Whoever did the shooting took the gun from the scene. And maybe that suspect is arrested, a week or a month later with the gun on him. Then they can actually do a comparison of the bullet found at the crime scene and the gun that was recovered. What they could also do is compare the shell casings too. Those casings, when they leave the gun, they can fly all over the place. So a lot of times when officers are first responding to a scene, they kind of need to look around the street or a sidewalk and, hey, are there shell casings on the ground? What do we need to, we might need to collect those for evidence purposes. So firearms and DNA are two of our biggest forensic evidence, pieces of forensic evidence we have in our cases. Continuation here on guns. Yes, shell casings, those are very commonly used to compare. Obviously, if we don't get the murder weapon, then sometimes shell casings don't really help us. Bullets are harder to compare. Shell casings leave more distinctive marks. The firing pin that hits the bullet, usually those are distinctive, kind of like a firearm fingerprint, if you will. And then gunshot residue is another piece of evidence. We're seeing kind of less and less of that, but every time a gun is fired, the kind of the residue, the powder, because every cartridge has a little bit of gunpowder in it. And when the bullet, leaves the barrel, there's powder that's ejected, not just through the barrel, but all around. And if somebody says they weren't in the presence of a fired gun and they have what we call GSR on their hands or their clothing, then it could maybe put them at the scene of a shooting. Sometimes we can get DNA off a gun or even the casings when they load the bullets, the rounds into the magazine. Sometimes if they, their hand touches it, if DNA is deposited. One of the things I didn't say about DNA is just because somebody touches something, that doesn't always mean that their DNA is going to be deposited on that surface. So usually body fluids are much better than touch, but sometimes every once in a while, somebody's sweating or they shed skin cells, they can leave DNA on a surface. We do use that obviously with forensic pathology and autopsies if they do have to unfortunately remove a bullet from somebody's body after they've been shot. Next. Trace evidence. I won't get too much into this because, and this is something, again, I mean, there's probably so much, out there on, but we've seen it every once in a while, we'll see it. A hair or fibers, even paint or glass, gasoline. I mean, that's used in arson cases all the time. We do get those. House fires. Was there an accelerant used? Can they chemically be able to tell, if somebody put gasoline in a house and lit it on fire? Even soil or dust sometimes can be samples. If they find, somebody goes to the park and finds the remains of somebody, maybe they've been there for years and we find bones or something in those kinds of cases, they can maybe collect samples from the soil around it, or some of those things can be used in trace evidence, but we don't see that too much. That's more what we see on TV, but we do use those kinds of evidence every once in a while. And next slide, handwriting. We do use this every once in a while. Sometimes we do need to compare the handwriting. We see this more in like what we call, fraud cases, or what prosecutors will call paper cases, where it's really all about, documentation. And if somebody's committing fraud or it rises to the level of criminality, we will compare handwriting samples. We do that, but I think they do this more in federal court where they prosecute a lot more of those white collar crimes. Next one. Fingerprints, yes. One of the things I like to remind everybody and tell everybody about fingerprints is they are unique and they can be used to prosecute criminal cases. I've used some in my career in the last 5-10 years. But one of the things about fingerprints that people kind of, one of the myths out there is that if you put your hand on a surface, you're automatically going to leave a fingerprint. Well, that's not always true. I mean, that really depends on, the surface you're touching, what part of your hand touches it. Like if you touch a glass, most people say, okay, that might leave a good fingerprint. But if you're touching a different surface, like a countertop or wood or an uneven or irregular surface, like a gun or the handle of a knife, usually the only way fingerprints are valuable if they can get a nice, solid, round print. And that's oftentimes that's hard to get. So when people think, somebody was holding a gun and, if they touched it, their fingerprints are on the gun. More often than not, that's very difficult to do. We also see that kind of juries expect in, say, a drug possession case where a baggie is found of drugs in a car with 4 people riding in it and everybody says they're not mine. Well, why don't you just look at the baggie and get a fingerprint off the baggie and that'll tell you who, had it. Again, that's a surface that's really difficult to get a fingerprint off of because it has to be a nice, clear kind of swipe. So we do use them, but they're more difficult to kind of peel off a surface than people think. Again, very rare, but we see this a lot. Accident reconstruction. I had a case just a couple of years ago, a terrible accident, on Akron's residential streets. And the highway patrol actually came in and they do a fantastic job of reconstructing that scene. They're able to tell how fast cars are going and the path they took. And because sometimes if you see the end of an accident, you see a car flipped over or turned around, They can kind of analyze that scene and figure out, well, that may be how the cars ended up, but that's not where they were traveling. Forensic pathology, that's basically what medical examiners do. Chemicals, we deal with, toxicology screens, with DUIs, and if a rape victim says that they were, somebody slipped something into their drink, we can use that. And every once in a while, like I said, entomology, that's basically the science of bugs, and that can kind of be used to determine some things. Forensic dentistry, if they need to use dental records or bite marks, that kind of thing. So we do see that, but not as much. But those are a lot of the pieces of forensic evidence. So I'm going to shift now, and I know I don't have too much time, and I do want to leave some time for questions. But it's very important to talk about the burden of proof, and it seems like a kind of a boring or dry subject that people maybe don't quite understand, or who really cares, or they don't really talk about that in the media. But when it comes to criminal cases, burden of proof is very, very important. As you can see in this kind of graphic that I have here, there's sorts of levels of burden of proof. And in the criminal context, what that means is it's not just that we try to find somebody guilty, but what we also have to do, especially as prosecutors, and this is the top level that we see, is how guilty are they, or how much evidence do we have to convict them? In the middle is preponderance. That's most civil cases, a car accident, medical negligence, anybody suing somebody else for money. They have the burden to only prove a preponderance, meaning if there's a car accident case and I have to prove it's your fault, if it's like 51% your fault, like just enough over the middle, then I would win the case. I only have to prove it's, more likely than not, 51%, just to tip the scale. But in a criminal case, like you see at the top, beyond a reasonable doubt, that is the highest burden we have in the criminal justice system. I think that's very important. That's one of the protections we have, that we can charge somebody all day long, but if we can't prove them guilty beyond a reasonable doubt, then they don't get found guilty. The evidence, in other words, should basically be overwhelming, or it should be enough evidence that a juror weighing that evidence says, I am firmly convinced that this person did it. If a juror is sitting there saying they probably did it, but I don't know, then that's not enough evidence. And then we don't get a conviction. So the burden of proof, or how much evidence we need to prove, is also very important in our cases. And I think that's something that isn't talked about enough, that people should understand. Burden is on the state in a criminal case, always. One of the things we always talk about in trial, and defense attorneys talk about it too, they don't have to prove a thing. It's all on the state. We're the ones that have to present the evidence. And if we don't present the evidence, if it doesn't rise to the level beyond reasonable doubt, then we don't win. And that's the way it should be. Because if somebody's going to get convicted of a crime, the evidence should be strong. And it's always on the state. So the defense can sit there, and they usually don't, but a defense attorney, he can sit there and play on his phone the entire trial. And if we don't prove our case, then they can win. We do present the evidence. And again, they don't have to present evidence, or defendant certainly does not have to testify. That's their Fifth Amendment right. And we can't comment on that either if they choose not to testify. That because of what I was talking about, that's how we can talk about not guilty versus innocent. Just because if somebody gets acquitted at trial, the jury will find them not guilty. They don't find them innocent. And why we have that difference is somebody could be found not guilty, and the evidence could be maybe more than 50%, like more probable than not. But some of the jurors might say, I think he did it. I think there's some evidence that she did it, but there just wasn't enough evidence. So maybe he did do it, but we just didn't see enough evidence. That's why our verdicts are always guilty or not guilty instead of guilty or innocent. Just because somebody's found not guilty doesn't mean they're innocent. It just means we didn't have enough evidence to convince a jury that they were guilty. I think I have a few minutes for questions. I wanted to keep on track. I think I saw a few pop up in the chat.
There
Um,
are. I
we-
could start them to you.
Yeah.
So the first one was from Joan. She said, "Does this ever become overwhelming to the investigators? I would think that dealing with this type of intensive actions against human beings could," and I just got cut off, "could take its toll."
Yeah, I mean, honestly, I think it weighs more on police officers than prosecutors. By the time we get the case, everything's already happened. I mean, they're the ones on scene that are literally, I mean, unfortunately, I hate to get too into that, but that's what we're dealing with here, folks. Is police officer has to respond to somebody who's dead or dying, or they have to respond to somebody who just said they were just raped. That can take their toll, and it can take its toll on prosecutors too, because we're reading about all this stuff, and we meet the family members of victims, or we meet victims if they're still alive. That's why every once in a while, and I know there's, something might come out on a body cam, or, people hear about things, and sometimes you almost have to have, kind of a thick skin and to be able to talk about this with other people in a way that doesn't personally affect you. And it doesn't mean we're trying to be insensitive, but if we're going to do this job for years and years and years, you have to find ways to cope. And we all do that in our own way.
This is a question from Missy, and Brian, I think you could answer it a little bit, because we are going to get into it in further discussion. So maybe just give a little snippet. But I know you know the answer very well. But with rape cases, how far does no mean no go?
Rape has to, I mean, we're talking consent. If a victim, I mean, there's male victims too, but usually it's female. If a female victim says she said no, then we're looking at a potential sexual assault case. Not to get too much into it, that's something you might want to ask when you guys hear about sexual assaults and rape cases. But one of the most important things is rape has to be force. If it's a child, obviously that's rape, no matter whether there's force or not, or there's someone, if it's somebody who's, intoxicated beyond being able to get consent, that's also something that, can be a thing. But we just because if somebody says the word no, but then there's no force used, or they acquiesce. I've actually had to review a few of those recently, where somebody was like coerced, or like the guy kept asking me, and finally I just said, okay. That's awful, but it doesn't rise to the legal level of rape. But that'd be something tuck in your pocket, because you'll have a whole presentation, 45 minutes on rape next month.
And then she also asked, thought the medical examiner in Summit County no longer checks for GSR, gunshot residue, because it's not credible.
I think that is true. I don't think they do, and I don't think it's because it's the evidentiary value of it has gone down so much, because the particles get dispersed so much. Just because somebody has gunshot residue on their hands doesn't mean they're the shooter. They could have just been in the presence of a shooter. There's also other substances that can mimic GSR, especially around the 4th of July, fireworks. But they basically, I think the science was there in terms of, we know powder residue does come out of the gun. And we can request that testing if we feel it's relevant by other resources, namely the BCI, or Bureau of Criminal Identification, like the county, the state crime lab. They might be able to do some testing, but that is true. We don't use that as much. The only way I could see that being relevant, if somebody said, I was nowhere near a gun being fired at all in the last week, and then there is residue on their clothes, then we can show that they're lying. But if it's at a party or outside, and sometimes we see that where there's 50 people around and a gun's fired, there's a chance almost all 50 people might have a little bit of residue on them somewhere, because that powder can really disperse in the air depending on which way the wind's blowing. So it isn't as reliable, and we don't use it as much as we used to.
Okay. Another question was, what are the fibers on the list? Is this clothing fibers?
It could be. Every once in a while we have fibers deposited. It's rare, but think underneath the fingernails of a homicide victim or a rape victim. They were grabbing at somebody's shirt. They were grabbing at somebody's coat, or somebody broke into a house, or an aggravated robbery or burglary, and when they jumped out the window or they put their hand through a window, some of their clothing tore, and there's some tiny little fibers on the windowsill, or where there's glass broken, or like I said, under a victim's fingernails. They can look at those things under the microscope, and if they have a suspect and they think they knew what he was wearing, they can compare things like that on a microscopic level.
Okay. And then Ashante, I think that's the last in the chat of the questions, but Ashante has a question she wants to ask you.
Okay.
Sure.
Hi.
Hi.
How do you prove that something is beyond reasonable doubt if it's in relation to mental health? For example, when does fact / evidence become a matter of opinion? Is that easy to prove in court that someone has a mental health issue, or do you guys find that harder as prosecutors to prove that mental health was beyond reasonable doubt the reason for a crime?
And actually, mental health rarely comes up because I really can't think of a crime where mental health is an element of a crime. The one area I'm thinking is somebody says they're not guilty by reason of insanity. That's one of the things that first comes to my mind. But most of the time, if somebody's on trial for, say, stealing something, their mental health doesn't come into play unless they say they're not guilty by reason of insanity, and that's a legal standard. So they would have to get interviewed by a forensic psychologist. If the defense claims that, then the defense gets to hire their own psychologist, the state hires a psychologist, and they have to have a mental disease or defect under the law. That's what the law reads. And not only that, but it also has to, act on them in such a way that they didn't know right from wrong at the time of the crime. So I've had reports where people come back and they say they have bipolar or they have schizophrenia, but the opinion is that they still knew right from wrong, because there's a lot of myths regarding mental health. And just because somebody has one of those conditions doesn't mean they're just, out in the clouds all day long. They have moments of lucidity. They can have conversations. And so under that context, it would be kind of a battle of the experts. Maybe a defense expert says, they were suffering from schizophrenia and they didn't know right from wrong. And a state expert might say, well, they do have schizophrenia, but they could tell right from wrong. And like, I have a case pending right now, I can't say which, where they are claiming that, but the suspect cleaned up the crime and tried to cover it up after they committed the crime. Mm-hmm. And that's indication that they did know what they were doing, because they knew what they did was wrong, so they were trying to cover it up.
Right.
So that's one of those things we could use. But really, unless in that context, mental health doesn't usually come up in a trial unless they're trying to present not guilty by reason of insanity, or what we prosecutors call NGRI, unless they're presenting that kind of issue.
Thank you.
Of course. Were there any other questions?
Hi, I just had a quick question about what type of education or training is needed when you're looking at different types of forensic evidence. It sounds like some of this is very, very specialized. And so as a prosecutor, when you're reviewing evidence, what type of training or education is needed, if any, in order to properly interpret it?
Well, yes, if we present that evidence, we're bringing in the experts. The DNA analysts that work at the crime lab that we deal with all the time, they have to have a bachelor's degree in forensic science or biology, or microbiology. I guess you could have different degrees, but they usually have college degrees. Police don't. A lot of police officers do have college degrees, but when it comes to fingerprint evidence or like maybe splatter evidence or something like that, a lot of police officers get what they call like a master investigator title or license. They might go through like a 3-month training or training over a span of a year, additional on the job training to be able to process fingerprints and stuff like that. So it doesn't always require like a college degree expertise level, but police that handle that kind of thing and definitely interpret that stuff, they have to have lots of extra certifications beyond just being a police officer.
We have another question in the chat from Valerie. Do you use polygraph evidence or body language experts in trials?
Almost never. That's incredibly rare. Most of the time it's the defense taking, they give their client a polygraph and then come to us and say, see, he passed, please dismiss the charges. Usually not that simple. Every once in a while, if a defendant, and I haven't done this in a long time. I think it's still around. The Akron police used to have a polygraph examiner. I don't know if they still do, but if a defendant honestly said, I wasn't there, you have the wrong guy. Sometimes I would say, have him take a polygraph, because if he passes and my examiner says, hey, we really think he's telling the truth, then we might take a second look at the case. But the evidence, those results, they're more of an investigative tool because they're not admissible in court. And we never polygraph rape victims. We would never do that. Even rape suspects, especially sometimes, unfortunately, my child rape cases, they're really in denial. And sometimes I get defense attorneys saying, what about a polygraph? And sometimes I just think it's not reliable. And some people in their own head think they didn't do anything wrong. And polygraphs need to be a black or white issue. Were you there or not? Did you hold this object or not? Did you drive this car that day or not? But if, did you molest somebody, then it becomes subjective. And I don't like it. Just polygraphs don't work into that situation. So anything else?
Someone just kind of said a little bit about, like Nathan just said, aren't polygraphs flawed? Just like you said, Brian, as the anxiety could trigger a lie, or those who know how to reduce their anxiety can pass. So yeah, that goes along with what Brian just said. Are there any other questions? If you want to unmute, just to make sure I didn't miss anyone in the chat. All right, we had a lot of compliments in the chat, Brian. You did a great job.
I tried to squeeze it. It saves time for questions too.
You did. You guys are awesome. So I appreciate that.
I tried to hit the highlights. So,
thank you so much.
I'm sure Tanya, you can always email her more questions, and we'll always,
definitely
as an agency, we'll always answer any questions like this from anybody, anytime.
Thank you, Brian, for your time.
Thank you so much.
All right. Thank you all for doing this. Thank you.
Thank you.
All right. Bye-bye.
Bye-bye, Brian. Okay, so last but not least, I will be presenting on our justice system, kind of an overall issues, sort of stats thing that talks a little bit about DEI and other topics that I think could lead to a lot of discussion. But I know we're running short on time, and that's kind of the problem. But I will be staying later if anybody does have any thoughts or questions or more stats that they want to see. I'll be here. So I just want to preface these big topics with that fact that we will stay on after to keep the conversation going. I'm going to share the screen, James, but if you can pay attention to the chat for me if there's questions, I'd appreciate it. Just a little bit of background about me. I've been a lawyer for 15 years, and I've been privileged enough to work every aspect of the justice system. So you could kind of see where my mind is going in these thoughts that I'm going to be presenting to you. I've been a defense attorney, a magistrate as like on the bench, and then now as prosecutor. So I got to work every part of it. And what I have learned is there's always more to a story, right? We can't just look at things as a single story. So I am going to share my screen with one of my favorite little snippets of a video. I think it would be awesome if you guys watched the whole one, but I'm just giving you a short one because we are low on time. And I'm gonna have to ask someone to unmute when I can get Uh, Can you see the screen?
Yes.
I'm trying to find a presentation mode, but maybe I'll just.
Yeah, it's not clear. Oh, it's clearing up a little bit. Maybe it's there. That should
Okay,
do
which
it.
screen are you seeing? Are you seeing the screen that just says Summit County Prosecutor's Office and the justice system, or are you seeing like my
The
little?
presenter screen
Yeah, you've got the
with both
presenter
screen, the
screen up.
next screen as well.
Yeah, yeah.
Okay, hold on.
Go if you switch at the top.
Yeah, I think what I'm gonna do is.
You got multiple monitors going on? Because
Yeah,
you have multiple monitors?
I
Yeah.
do. Okay, give me 1 minute. I'm gonna try this one more time and then you guys tell me. Are you still seeing my screen? 'Cause I don't
Nope,
think I can.
not yet.
Okay, hold on. Let me get back on it. I'm wasting precious time. Let's try this. Okay.
All right, there you go.
Now,
It's-
do you see?
Yeah, you just have to do, there we go. Now we're good. Yep, it's clearing up. And I don't know if it's my internet, but it seems a little out of focus, but I think you'll be okay.
Okay. All right, I'm gonna press play. Can you hear it?
I come from a conventional middle-class Nigerian family. My father was a professor. My mother was an administrator. And so we had, as was the norm, living domestic help who would often come from nearby rural villages. So the year I turned 8, we got a new houseboy. His name was Fide. The only thing my mother told us about him was that his family was very poor. My mother sent yams and rice and old clothes to his family. And when I didn't finish my dinner, my mother would say, "Finish your food. Don't you know people like Fide's family have nothing?" So I felt enormous pity for Fide's family. Then one Saturday, we went to his village to visit. And his mother showed us a beautifully patterned basket made of dyed raffia that his brother had made. I was startled. It had not occurred to me that anybody in his family could actually make something. All I had heard about them was how poor they were, so that it had become impossible for me to see them as anything else but poor. Their poverty was my single story of them. Years later, I thought about this when I left Nigeria to go to university in the United States. I was 19. My American roommate was shocked by me. She asked where I had learned to speak English so well and was confused when I said that Nigeria happened to have English as its official language. She asked if she could listen to what she called my tribal music and was consequently very disappointed when I produced my tape of Mariah Carey. She assumed that I did not know how to use a stove. What struck me was this: she had felt sorry for me even before she saw me. Her default position toward me as an African was a kind of patronizing, well-meaning pity. My roommate had a single story of Africa, a single story of catastrophe. In this single story, there was no possibility of Africans being similar to her in any way, no possibility of feelings more complex than pity, no possibility of a connection as human equals. So that is how to create a single story. Show a people as one thing, as only one thing, over and over again, and that is what they become. It is impossible to talk about the single story without talking about power. There is a word, an Igbo word, that I think about whenever I think about the power structures of the world, and it is Nkali. It's a noun that loosely translates to be greater than another. Like our economic and political walls, stories too are defined by the principle of Nkali. How they are told, who tells them, when they are told, how many stories are told, are really dependent on power. Power is the ability not just to tell the story of another person, but to make it the definitive story of that person. The Palestinian poet Mourid Barghouti writes that if you want to dispossess a people, the simplest way to do it is to tell their story and to start with secondly. Start the story with the arrows of the Native Americans and not with the arrival of the British, and you have an entirely different story. Start the story with the failure of the African state and not with the colonial creation of the African state, and you have an entirely different story.
Okay, so I wanted to start with that because I think it's important. I think it's important to know that when we share our information, there's always more to a story. And I think that we see a lot in our media and we see one side, and now you're hearing another side, and there's always another side. So we just always have to remember in the back of our head, there's more than one story here. And so I wanted to kind of give you guys a little bit of a glimpse of the beginning of our cases. Like, how do we get it? What is the process? And we talked a little bit about this stuff in grand jury. I'm going to kind of stress some things that weren't stressed, but that you may have seen before in our last set of slides to just paint the picture for you, just so we could start from the beginning. So when does the Summit County Prosecutor's Office become involved in a case? And there was kind of a question on this, like when do we get this case? And it's really, it's after the law enforcement make the arrest, they do the investigation. There are some more serious crimes, more administrative crimes that we will do secret indictment, which we talked about in grand jury. But we want to remember that we're not the police, we're not the sheriff. We are two separate, distinct offices. But when we do the work, we have to work with them in order to get the case and then investigate it. So just remember, we're two separate offices. So we talked a little bit about grand jury. We talked about how many cases we see every year. We get about 5,000 cases that come to us from other agencies, and grand jury, as we talked about just now with burden of proof, will determine yes or no on a case, whether it needs to go into our court system, yes or no, by probable cause. And they really are the first review of an arrest case. We will review once we get it from the police, but they are the ones who decide. They're the gatekeepers. They're the ones who decide whether or not this is going to go inside our court system. The grand jurors choose what moves forward. So let's look at some 2021 stats. Some of them that we saw previously, but again, I'm trying to tell a little story here. And I want you to keep in mind that our statistics are compiled manually. These are not meant to be taken as, okay, well, 216 cases are rejected by felony. Maybe it's 218. I don't know. We're not exact because we are human. And we do have a new matrix system, but that system is only as good as the humans who are inputting into it. So we're trying to look at our pictures and our stories and to see what there is there. And this is what we've compiled. So just remember, this is a little fluid just because we have a newer system and we are trying to manually track these. But we have some discretion, right? When we get a case, do we present it to the grand jury or not? You'll see that we've rejected 216 cases with pre-indictment dismissal. So before it was indicted, 19 of those cases were dismissed. So maybe they went past the rejection mode, but right before the indictment, they were dismissed. And a lot of this happens to be maybe there wasn't a sufficient information. The officers didn't complete the investigation. There were issues, with witnesses and things like that. The grand jury has remanded 184 cases, which means they're saying, well, this isn't quite what a felony looks like, okay? The grand jury determines that the case just maybe could be a misdemeanor, not a felony. So they're going to remand it. Our grand jury has also no-billed a case, not even remanded. They just say this is not a felony or a misdemeanor. So we have 173 of those cases. And then post-indictment dismissals, after a case has been indicted, the grand jury determined it, through the continuing process of gathering information at the prosecutor's office, as the defendant might be represented, they provide some more information, or we gather some more information, we determine that there's 163 of those cases that we dismissed. So in 2021, we had approximately 5,421 cases, and about 4,358 cases were fully prosecuted. So we're about 13% of our cases being screened out or dismissed by our grand jury. So we always look at our murder stats, and I think it's important to look at, you know, what type of crimes are being committed in order for the result to be more murder. What kind of murder cases are these? And what is the ethnicity? Because nationwide, like I said, there's a story, right? We see in the news, you know, we talk about race, but what is happening in Summit County? And so remember, these are manual. We're looking at cause of death. So it looks like gun violence is a huge problem. Most of the cause of death, and that's 55% of the cases, the murder cases that we have are committed by the use of guns. So what story does this tell us? You know, does it tell us that there might be some gun issues in Summit County? Does it tell us, you know, that maybe we need to look at our gun laws? Maybe we need to look at who's holding the guns. Maybe we need to go in the community, because a part of my presentation today is going to talk to you about, you know, what are we doing with these stats? You know, what does this mean to us? So you're going to see knife stabbings. We have 11 cases. I'm not going to read through all the stats. I'm kind of letting you look at them just to get an idea. And remember, I'm not a statistician. I have talked to the university to see if we can actually get one, because, you know, I'm just a lawyer who's picking up some stats, and our office is trying to work hard on it, but there might be better stats to keep, or there might be different interpretations of when I see this, what does this really mean? And, you know, obviously, you know, the university is short staffed, as they told us, and we're hoping to get a grant to be more, you know, detailed in terms of what does this mean? But I think it's still important to look at it. We're looking at then, so we looked at the causes of death, and we see that gun violence seems to be, you know, a huge majority of how people are being murdered. And then we're looking at who is doing the murdering and who is the victim. And I think these numbers could be, you know, important if we actually also look at Summit County. What does our population look like? You know, what is the ethnicity of our population? You know, do we have more white than black? Do we have, you know, a higher percentage of Middle Eastern than Asian? To see if it's congruent to the crime, right? Like to the numbers that we're seeing here. And so you're going to see that there are more defendants than victims in the totals, because there might have been multiple shooters, less victims, in this case, in this 2022 stats. But you know, the other thing is, like, how do we really even know the ethnicity of someone except by looking at their name and their skin color, or if they self-identify? So you have to think about the flaws that we're seeing in these stats as well, right? Like, you know, these are just humans trying to paint, to look and see, like, what can we see, if anything, that can help us get out in the community and make a difference and impact in a way where we can be preventative. So remember, I'm going to keep saying it, these are not absolutes when we're talking about our stats. These are the best we can do right now, and hopefully we can get better as the time goes by. But again, still think it's something to kind of look at here. Okay, so we talked a little bit about after grand jury. So we looked at the cases, what they look like, what kind of crimes are we looking at? But then what happens after grand jury decides that this needs to move on into the court system? And we kind of covered this, so I'm going to go through this slide a little fast. I'm just trying to remind you of what we reviewed on the last meeting. We talked about, you know, arraignment. You know, the defendant, once the grand jury determines that this case needs to go into our court system, the defendant gets arraigned. And then that's where the bond is set. And then they're going to have a pretrial, and they may have more than one pretrial. Usually with pretrials, they're the time to go through discovery, which is the third step, where, you know, we talked about in the Brady case, where we have to hand over all the information we have, all the ballistics, everything that we have to give. And it's also negotiation where, you know, the defense attorney will say, okay, they're going to give me a story of what their client is going through. What do they need? What sort of issues do they have? What happened to cause this? And we're gonna, you know, listen to that. And because that's a part of this negotiation process, like, because remember, there's more than just one story. You have a victim who's been harmed, and you also have a defendant who may have been harmed too. And so we we have to look at that. And then in the negotiation process, there's things that we can talk about. We can talk about diversion, which I'm going to, shed more light into. Intervention in lieu of conviction. We're going to talk about our specialty courts, our prison system. Prison could be part of the negotiations, maybe a certain amount of time, and then probation. And then if that negotiation step doesn't work, and they've, the lawyers have looked at the discovery, negotiations, aren't working, then you end up going to a trial. And so that's kind of the steps, after grand jury of where the case and where this goes. So let's talk about negotiations. The first thing that we talked about, and I'm going to try and go quick because we don't have a lot of time, but I will stay after. Diversion. The diversion program is kind of limited, and you're going to see the stats on this in a minute. An individual qualifies for diversion if they are charged with a low-level felony, not a violent crime, not a drug-related crime, had no prior felony convictions, and the amount of damages is less than $5,000. Well, this is run by statute. There's a statute that defines what the prosecutors can give as diversion. And so look at our stats. And I put both years in here to let you see how much of a decline we're getting in diversion requests. So the cases get referred, the defendant, and sometimes not even the defendant. Sometimes when I'm in court, I'll say, well, this person looks like they qualify for diversion. And then the judge will say, okay, does the defendant want that? And diversion is a program where if they go through all the steps that are required and they qualify, and they go through the probation, they can get their case dismissed. And so it would clean their record. And that's great, right? So they made a mistake, they won't make it again. And they're going to ask that their record be cleared so they can move forward in their life. And remember, the Ohio Revised Code determines those elements I showed you before, the under $5,000, no previous felony. And the prosecutor's office does not have to have a diversion program, but we've had one for 20 years. Our prosecutor, Sherry Bevan Walsh, always believed in that option. And so you're going to see these numbers. Like, we only had 44 cases in 2020 be referred for diversion. And now we have, in 2021, we had 21 cases. And I think they're even smaller in 2022, but we haven't finished the year. That was troubling. That's troubling to me. And what does it tell us? What story do these numbers tell us? Well, it might tell us that, this code, this statute that's controlling what kind of diversion can be given is kind of obsolete at this point. It's not working. It might tell us that the crimes are more severe now, we're talking low-level crimes, less than $5,000. Maybe not as many people are committing those anymore. Maybe not as many of those cases are being charged. This is why I think stats are important. There's so many things that we can look at and should look at when we see this decline. Another option is intervention in negotiations, intervention in lieu of conviction. It's just like diversion, but it goes through the court, not through us. The court determines, the judges determine if someone can get, they call it IILC, intervention in lieu of conviction. And there has to be a drug or alcohol or mental illness factor related to the offense. And believe it or not, you could make most offenses drug, alcohol, or mental illness related, which also tells us something, right? They can't have had a prior felony, and it has to be a low-level crime. So intervention in lieu of conviction will do just what diversion does, but it kind of gives us a little bit more to work with. So then after that, we have our specialty dockets. I'm guessing many of you have heard of our specialty dockets. These are run by the court. Each judge has their own specialty docket, and we participate in it and are a part of it. Some of us sit on the boards of these specialty dockets to make sure that they're options for defendants. We have Turning Point, which handles F4s or F5, and it does have to have police and prosecutor approval. And they must be able to participate. It deals with drug and alcohol addiction. We have Valor Court for our veterans. And we also have domestic violence court, and that is really intense. It deals with our high risk offenders. They're placed under intensive supervision. This is run by the judge, and the judge meets with them on a weekly basis. And then we have Hope Court, which again is similar to Turning Point and Valor Court. and that we're working with F3, F4, F5s, lower level. But it's also pretty intense and consistent, where the judge meets weekly and they have to meet like very often, and also they have a lot of resources available to them. So they're trying to get every resource they can: housing, work, mental health care, and medicine that's needed if it's needed. So remember though, these are looking a lot more at lower level felonies, F3, F4, F5s. So I want to go back a little bit to our total cases. We kind of talked about negotiation, and I'm kind of jumping back to, okay, we went through the process. What do we end up with here? And this is our total caseload. I'm giving you kind of a gamut from 2019 to 2022, and it looks like I'm running low on time. So if you have to log off, I understand. I have just a couple more slides, and I apologize for going over. But we got 2019, 2020 to 2022, and you're going to see our caseloads in these years. 2019 was a pretty hefty year, but it talks about, we're looking at, the nationalities of individuals, the ethnicity, what percentages are we looking? What does this mean, right? We have 38% in 2019 of Black individuals who are defendants in cases, and then we have 40% in 2022. To me, that means something. There's an increase, and then we can look at white. We have 60% in 2019, and then 57. So it's a slight decrease. Why? What is going on here? And that's something for us to get out into the community and try and figure out. So what do we do? There's things that we do in our office, that we have diversity, equity, and inclusion. We look at these race factors to see, okay, what can we do? It doesn't mean, oh, well, if we see a white person, we're not going to prosecute, or vice versa. That is definitely not what it means. We don't look at race when we present to the grand jury. Doesn't mean that our grand jury members can't figure it out if they're looking at the street, but we have to be the street where somebody lives, or if there's these implicit biases that could be there where someone could figure it out. But what their race is at the time of grand jury, our prosecutors are not looking at that. But what are we doing? So here's some things that we are doing. We started Ambassadors for Equity and Social Justice Committee in 2020. And that committee is comprised of a diverse group of people from our office, diverse in their profession. We have administrative staff, we have social workers, we have victim advocates, we have attorneys, and then diverse in their ethnicity, diverse in their religion, just as diverse as we can get. And this group of 12 people meet bi-weekly for 2 hours. We talk about the hard issues, the cases that are going on. And we also part of our goal is to move into the community and talk to our community and work with our communities and see what can we do to help make things better, to prevent crime. We held earlier this year, we held like a community forum where we had a judge, defense attorney, a victim's mother whose son was killed by a juvenile who committed a crime in his younger years, and a prosecutor. So all aspects of the justice system sit in a room and talk about our justice system. And that was held in earlier this year, and it was a community forum with great questions, great conversation that we are following up on, hopefully by the end of this year. We do DEI training for staff and law enforcement. We also do diversity and inclusion training. 2 of us in the prosecutor's office have received certificates from University of Rutgers and Cornell University in DEI. We also have a dedicated prosecutor for immigrants who become victims but are afraid to come forward because of their status in the United States. That prosecutor will not obviously give anyone a green card because they can't. The federal government can only do that. But they will sign a document saying that that individual participated in the investigation or prosecution of somebody who committed a crime. And with that signature, that enables an immigrant to apply for a potential green card. It's up to the federal government whether or not to give it to them. Other programs we provide based on, some of the things that we see are Arrive Alive. Especially we've been doing Arrive Alive, I forget for how many years, James, but we've been doing it for many years, a lot, mostly when we saw that there was alcohol related crimes, too many of them. And this program gives people rides during the bigger holidays to prevent them from having to drive, drink and drive. And so we always team up mainly with the sheriff's office to pay for these rides for individuals. We provide newsletters for seniors and newsletters on our office and things that we see, the crime that we see, so that we can educate our community, telling them about these crimes so that they don't become victims of it. We realize that there's a lot of crimes that are occurring against seniors. And so we started recently a senior protection unit. And that unit is geared specifically towards seniors who have been harmed in any way. And a lot of it comes down to scams, or a lot of it comes down to their own family members who are taking money and taking advantage of seniors. So that's a newer specialty prosecutor that we have, and it's a newer program when it comes to our seniors. We also get out there into the community and talk to our seniors about the scams that we've been seeing, again, to prevent them from becoming victims themselves. We started a victim awareness campaign in multiple languages because we're aware of the fact that we have individuals who don't just speak English. And in addition to providing how can we help information, we also provide a Start by Believing program where we help individuals understand how to respond to victims when a victim comes to you and says, I've been harmed. The main thing to take from that is we don't say, well, why did you do that? Or, question them. We just say, what happened? Tell me about it. We let them tell us what happened, their experience. And it's important to make sure that we start by believing. And we also have noticed, even internally in terms of, who's applying for jobs, who's not, we're not getting a lot of diverse applicants in the career force. And we're also seeing an increase in our juveniles, crime within our juveniles. So, based on that, we started going more into the community, into our schools, to talk to our students about sexting and bullying, and to encourage them to apply for internships and expose them more to our office. So those are just other programs that we have. So I am late, 8 minutes late, but I wanted to end with a quote that I think, kind of ran a good theme for this whole day of our class, and that the criminal justice system, like any system designed by human beings, clearly has its flaws. And I think that's a great quote because it's something we have, it's something we work with, but it definitely has flaws. So are there any questions? I'm going to stop sharing, and I apologize for getting through that.
There were a couple of items in the chat room scrolling through now. One was asking, how do you switch from the prosecution to defense? Does it get confusing at times?
Who asked that question? So how did I switch from a defense to prosecution?
It's got to be a different mindset.
Well, the beautiful thing, I will say this about the Summit County Prosecutor's Office, is it's not. I was actually, when I started in private practice at McGinty, Highlow, and Spellacy, it was a firm I worked at for 7 years. They were defense attorneys who were formerly prosecutors. So when I was first trained to look at things from both perspectives because they had that. And I'll give you an example, like DUI cases that I would represent defendants in. They said to me, there's too many people that are going through our system with addiction problems. And if we enable it by saying, okay, let me defend you, let me get you off on, whatever charge, let's reduce it for you. How are we really helping them? So, one way that we did this is if somebody wants to come to us and ask us to defend them, they have to enter into an assessment and get into a rehab in order for us to defend them. And if they won't, they can go somewhere else. So my train of thought really hasn't changed, from being a defense attorney to being a prosecutor, because at the Summit County Prosecutor's Office, we think the same way. Like, we're looking at the case, we're seeing our victims, and we are a victim-centered office. But we're also seeing, the other side. And we know that there's more than one story here. And we have to figure out a way to work together to help our community. And sometimes that can't happen. Sometimes it just means trial and we're ready to go. But, you know, sometimes we all could work together. So I don't feel like I really switched. I don't feel like from day one of being a lawyer to today, 15 years later, that I've grown, but I definitely haven't felt that I had to change anything in terms of perspective. Anybody else? Good question, John.
There was some more stuff in the chat.
Let me see if I can take a look.
Sorry, I'm writing a response right now.
So I had asked what the youngest person ever.
Oh, you did?
ever
I
got-
know a 16-year-old, I responded, I know a 16-year-old was charged and convicted for murder. Probably now been 10 years since that case.
Yeah, I think that's
I
the
don't
lowest
know I don't know about anybody younger. And Tanya, I believe though that did the state change how someone who's under 18 charged with a serious felony gets transferred to adult court?
Yes, they have. And there's always like obviously exceptions to every rule. So I think depending on if they fit the exception of 17 and maybe a 16-year-old, but really it's 18 and over. But they really try to protect juveniles. And there's new statutes out also with, you know, even juveniles who've been convicted. So mainly it's 18 and over could come into felony court. A 16-year-old I know in our office has been charged and convicted, but they have to fall within a certain exception. Some of the laws have changed, and if you guys were watching the serial case with Adnan, he was convicted at the age of 17. And the only reason that this case actually, even though it was appealed and so forth, the only reason that this sort of reconsideration was kind of brought to the prosecutor's attention, and that's when they saw the Brady violation, was because the law changed just like it changed here. If a juvenile commits a crime and is sentenced to life in prison, that can no longer happen. So Adnan was, and in Ohio now, if they are sentenced to life in prison, that can't happen. Judges can't say life in prison anymore. And then the other thing is, if they say, okay, 25 years, 30 years in prison, then, well, they also get to have parole before that. Depends on how many years they've been in. I think there's like a 15-year mark. They can get paroled every 5 years. There's different numbers to it that I'm not remembering right now, all the years. But what I'm saying is, they even went back, which was kind of my problem with it. Okay, I understand they make the new rule to not permit juveniles stay in prison forever because their minds are, not quite formed at the time. They're too young. But people who have been sentenced to life in prison had victims and victims' families sitting in, and usually it's victim family because those cases are really bad where it's heinous murders, sitting in court with a judge telling them, this defendant is going to be sentenced to life in prison. You'll never have to deal with him again. No chance of parole, no parole. And then that victim is going to get a call from us, which has happened already, where we say, remember when the judge said life in prison without parole? Well, he's up for parole because they changed the law. So they didn't just change the law, they also grandfathered everybody else in. And that's kind of where my sticky point was. You can't really go back like that, but they did it. And that's what they did with the Adnan case. They went back. And so that's what triggered the prosecutors, to look at the Brady stuff.
One of the people, I'm going through the chats again. Yes, COVID did impact. Jessica asked about the stats. Tell me COVID impacted crimes committed. COVID impacted every aspect of our society and continues to do so. From March of 2020, people were really staying inside. So, that impacted the number of crimes, and then we saw an increase.
It also impacted, officers giving us cases, right? Because they weren't citing for things like possession or lower level crimes. So we weren't getting a lot of cases, and then the courts were not scheduling a lot of trials. So in our stats, if you look there, you're not going to see a lot in 2020, but then in 2021, okay, everyone was inside. Cases weren't given to us. Trials weren't going forward. Officers weren't citing. And then all of a sudden, 2021, you see a huge increase in homicides, gun violence. Everyone got out and, kind of ran amok, right? And maybe, they were tired. They're tired of being inside. I mean, sometimes you look at the stats and you can kind of paint picture stories, right? By looking at them like that. But you could really tell 2021 took a big hit from that 2020 reprieve.
And then there was another question about, was there any, let's see, a couple popping in here. So if it wasn't worth it to cite those low-level crimes, why ever cite them at all, Mr. Ellie?
I don't know that anyone said it wasn't worth it. I was saying they weren't. And I think that's an excellent question. But I am not an officer. I can tell you in 2020, they were not citing for the lower level cases. And we were not getting them. And so, yeah, I mean, there's the question, well, why weren't they? Was it worth it to them? Was it not? It's definitely something to think about. But I didn't say that they said it wasn't worth it. I just said they weren't doing it.
And then Joan asks, how are they notified or taught about changes in law? Do you have in-services or occasional trainings? Whom do you get the info from?
What info? I didn't catch that.
I'm guessing that has to do with the change in the law for the juvenile.
Yeah.
Oh, so
How do you get that? I know as a teacher, I get in-services. They in-service us to death. But how do you guys, when they change a law, how fast are you notified and how are you notified?
Joan, another good question. So with that law, the Ohio Prosecutors Association was involved in the legislation. But we didn't see that until after it was passed. Once it was passed, because we do in-services, continuing legal education. We are constantly looking at legislation, and we get notices from the Ohio Prosecutors Association that gives us the new legislation that's even pending or that passed. But this one, for some reason, didn't catch our radar until after it was passed. And when we spoke with the Ohio Prosecutors Association, they said that this kind of was passed under the radar, that they did jump in to give their opinion because I think the legislators thought that they had to grandfather in all the other cases. And they tried to explain that you don't have to, you could just make this new legislation moving forward, but it didn't work out for them. And so we found out about it as soon as it was passed, but for some reason it didn't hit our radar before that. But we do have that continuing education. We do try to keep up as much as possible with the legislation.
Did you mention also our in-service, our monthly in-services?
We do monthly in-services.
For our prosecutors. Yeah. I think that was it. Is there another one in there in the chat that I missed?
This is something about the senior protection unit.
Yeah, just talking about who determines who gets help and how. It's Adult Protective Services. Summit County Adult Protective Services really handles a lot of that, but they notify us if there's a crime committed against somebody they determine to be elderly, then we're prosecuting the case and we assign it to that unit because the prosecutor in that unit is specially trained to handle.
So she's been working closer because a lot of times we weren't getting the cases, and
Yeah.
maybe law enforcement didn't think, the officers didn't think that it was a case, and then we would get a call on it, and we would look into it and we'd realize, well, there is a case here, and so our specialty prosecutor works with our service providers who are getting the reports of this elder abuse, and it's just more of a specialized thing where they're intimately working. She actually has an office kind of part-time there too, to make sure she's a part of that, so that we can make sure that we keep our community safe for our seniors, and catch the people who are taking advantage of them. And that all started because we started seeing there were more calls, there were more stats dealing with elderly individuals, and it's something we needed to do.
Jessica, you have your hand up. Did I miss that? You can take yourself off mute, or you took your hand down. So, oh, clapping. Sorry. It's hard to tell sometimes what the emoji is. Thank you.
Well, it looks like I didn't really get through all the questions, but on the chat, but I'm guessing we got through them.
Yeah.
If anyone has any other questions, feel free to speak up or send me an email. You guys have all gotten emails from me and you will continue to get emails from me. I appreciate you staying late, 20 minutes late today, and your time and listening to us and being here. So thank you very much for that.
Thank you.
Have a great night.
Wonderful.
We'll see everybody next
you.
Wednesday.
Thank you all for sharing your experience and information with us.
Thank you for your great questions.
Very interesting.
Thank you for everything. Good meeting.
Great meeting. Thank you very much.
Seemed like we had a lot of sexual assault questions. Do we know the date of our
Yeah.
the domestic
We are
violence?
It's
Do you have
gonna
the
be,
agenda?
it's going to be week 5 on October 12th.
October 12th. Okay.
So that's 3 weeks, 4 weeks, a month from today. No, 3 weeks from today. Today's the 21st, 28, 5, 12. So 3 weeks from today.
Was that agenda emailed out?
Yes, it
Yes.
was. Did you get it?
I don't think I
Yeah.
did. So if
Oh.
I could get
Can you
it,
email me so I can just make sure we have your email correctly in our list and I can get it to you?
all right, I'm gonna do that right now. Thank you so much.
You're welcome.
I missed it too, but I'll look for it. Thanks.
No problem. Thanks, Jessica.
Okay. Bye, everybody.
Thank you,
Great
Jane.
job, everybody.